Joined?
Am I audible? Hello.
Yes, sir. It's
Yes,
Sorry
Tauheed.
for the delay.
Yes, okay.
good
Tauheed?
evening, everyone. Yes, you
Yes,
can start.
Utkarsh.
Yes.
Hello. Hi.
Hello, good evening, everyone.
Good evening.
Please welcome our today's guest speaker, Advocate Mr. Tauheed Arshi. Tauheed Arshi is an advocate by profession and having experience of more than 5 years based on Delhi. Also, he is a nominated member of Advocatespedia. Mr. Tauheed Arshi has a wealth of experience in legal sector, specifically in human rights issues. Now he appears as as a defense counsel in criminal matters. I am excited to hear what they have to share with us today.
Yes,
Thank you, sir.
Tauheed.
Now the meeting
Hello,
is yours.
everyone. Hello, Faiyaz. Thank you
Sorry,
for giving me this opportunity.
just
Sorry for
just
the
a
delay.
second.
Okay.
Yeah, please.
Yes, Tauheed. So the concept is bail, right?
Yes, yes.
So
Legal
there are,
implication of the bail petition in India, I think.
yes, so they are the mostly students from first semester or maybe from second semester too,
Okay.
and they are willing to know about this concept. And since you are there, so it's pleasure to us to invite you on this platform and get interactive.
Thank you very much. Hello, everyone. This side. So,
Hello, sir.
am I audible to everyone? Yeah, hello.
Yes, since
Yes,
all
so
we
you are
have,
audible.
yes,
Okay,
since
okay.
we have informed the students to,
Participants can, sir, like
yes, no, it's okay.
participants
They
are
are,
free to use the chat box, sir. The participants are free to use the chat box. Chat.
okay.
For replying,
Okay.
please use chat box.
Okay, Tauheed, please carry on.
Yeah, basically, we'll talk about the provisions of bail in Indian legal system, and we will go through different kinds of bail with a perspective that how it is applicable in India, and what are the process to file bail petition in a court in different forum, and what are the kinds of bail. So for that, I will discuss various kinds of bail, and for this, I will refer few sections, maybe some international treaty also, and brief history about the bail concept of this bail petition. Basically, I will going to discuss type of bail, and under that umbrella of type of bail, I will discuss, try to cover in a bird's eye regarding the all the types of bail applications, bail provisions of bail. First of all, with respect to types of bail, see, for offense are of two category. One is bailable and second is non-bailable. So, being an advocate, we always have to be cautious about the nature of the offense prior to filing the bail petition in the court. And bail petitions are bail are basically, some bail has to be filed with respect to the offense that is bailable in nature, and another type of bail is bail that is in non-bailable offense. And if you are having or someone is having anticipation that case has been registered against some client, then on the basis of that apprehension, we have to move to the court that for granting of anticipatory bail petition. Now the next type of bail is bail on default. There are certain conditions which have to be fulfilled by the uh, inquiring authority. If those conditions are not fulfilled, then default accused person are eligible for default bail. Then there is a one more concept of interim bail, and lastly, I would throw some light on bail after conviction. That after, what is the role of advocate in these circumstances, that we will discuss in very brief, just to give you idea how this system works. So first of all, the concept, the term bail. its history can be tracked from earlier, I think 300 BC around. But first I will discuss the meaning of bail. There are various definitions of bail, but CRPC doesn't talk about the definition of bail, whereas Honorable Supreme Court and various courts of India and abroad also stated the meaning of bail. And basically, our court has relied on many of the definition. One was the Black's Law Dictionary definition, and it basically talks about it is a process to release a person from legal custody by undertaking that he or she shall appear at the time and place desired and submitted him or herself to the jurisdiction and the judgment of the court. What it means? It means bail is basically granted to those person on certain circumstances, on certain condition, that those accused person has to appear before the court whensoever court desire him to appear. So the concept of bail broadly captured under chapter 33 of CRPC. And see, there is a UN Declaration of Human Rights 1948, which talks about certain rights to human beings, and India is also signatory to that particular convention declaration. I'm sorry. So that the concept of bail came from that particular declaration also, we can say that, because when person are being convicted or are in the custody of state, then one must have certain rights. Those rights has to be guaranteed by the state. For that purpose, this UN Declaration of Human Rights was brought into the picture in 1948, to which the India is also signatory. And the concept of bail is resemblance to the conditions or the advice or to the Declaration of Human Rights. Moreover, if we talk about the history, then there are a number of sightings, but the first clear sightings happened in 399 BC, where the bail was basically concept of bail was introduced by in the form of bond that certain person will appear released, so that the bail. But this is the French terminology, which means to keep someone. The word bail is basically brought from the French terminology, but the entire concept has been evolved in England. So what is the object of bail petition? When we talk about, am I audible?
Yes, you are.
Yes, sir, you are audible.
Please let me know if you need any kind of clarification, because I'm going little bit fast, because I have to cover a number of topics, but I will
Please use
give
the
some
chat
time.
box, participants. Please use the chat box.
You will let me know if there is anything in chat.
Yes, sir. I'll surely let you know.
Please. See, the basic concept behind so we will talk about the legal implication, how advocates has to be prepared while doing practice, that what one should know, what are the types of bail. As I elaborated, as I stated earlier, there are a number of bail and types of bail petition, whereas what bail has to be filed before which court, this is very crucial. So basically, if offense is suppose someone has committed offense of bailable in nature, whereas bail has to be granted, it's a matter of right. But if someone has committed offense which is not punishable, which is non-bailable, then bail you cannot claim as a bail matter of right. Whereas point over here is, either it is a bailable offense or non-bailable offense, one must have to ask for the bail petition, for the bail through filing bail petition. So if someone has committed bail level offense and he or she is not moving bail petition before the court, then court will not grant bail even in a bail level offense. So for granting bail, it is very necessary that you must have to ask for the bail in a bail level offense or in non-bailable offense also. See, basically, I stated that chapter 33 broadly talks about the bail. And I stated what is the nature of bailable offense and how you can claim bail. Bail in a bailable offense is a matter of right. No court will deny that. If someone will ask, if someone will say that, okay, I am being accused of committing bailable offense, so he will ask or she will ask from the court to grant bail, and court has to grant the bail petition. It has been enumerated in a number of cases. And whereas with respect to the bail in non-bailable offense, one cannot demand bail or ask bail as a matter of right. It is a discretion of a court whether to grant bail or not. See, there are n number of judgments which talk about what are the conditions of granting bail and what are the in what circumstances bail should not be granted. Suppose if someone has committed offense, grave offense, like someone has committed such kind of offense in which death penalty or the life imprisonment is the recourse, then in that circumstances, one cannot say that you have to give me bail. It is not a matter of right. There are n number of judgment which talks about that bail should not be granted in such kind of condition. But to be very clear, there is only that particular court. If that court is satisfied that there is a circumstances and there are the fact of the case to which that court is satisfied that even the person is committed non-bailable offense, then also court can grant bail if court is satisfied that person is liable for the bail in non-bailable offense also. So it is totally upon the discretionary power of that particular judge regarding the bail non-bailable offense. So what is anticipatory bail? I already stated, when you have anticipation that you might be arrested by the police or there is some kind of case filed against you, then in that circumstance you can go to the court prior to any kind of such thing or that particular allegation. You go to court and state that I am having apprehension that someone can file case against me or police may arrest me. And if court is satisfied that okay, he is willing to join investigation, then court will grant anticipatory bail. And for that, there is not necessary nature of disclosure of particular offense, or we as an advocate we don't have to argue much on the fact of the case prior to filing anticipatory bail. Just we have to show our willingness to join the prosecution.
Yes, Tauheed, some students are asking to use both the
Okay.
language Hindi and English so that some of the
I'm very sorry. I'm very okay. No issue. Yes, you
And one
stated.
more
Thanks.
thing I have to
Thanks about
raise
that.
is since we are using Zoom for the first time, and
Okay.
the limitation for the timing, remaining 5 minutes are there to, I mean, to continue this meeting. After that, this will go end. So don't be impotent for all the students. It is asked to rejoin once it is out. So there will be new link or the same link will be there, Utkarsh.
Actually, there will be a new link. I'll just.
Okay, you share me. I'll share in the group and to the speaker as well.
Yes.
And that's how we can rejoin. And sorry for the interruption and inconvenience
No
caused.
इशू एट ऑल. हाँ देखो, ये अच्छा होता है कि अगर सबको समझ में आए तो ज़्यादा बेटर है.
Yes.
तो बेसिकली एज आई वाज टॉकिंग कि एंटिसिपेटरी बेल जब आपको ऐसा लगे कि आपको एप्रीहेंशन हो रहा है, यानी आपको ऐसा डर हो कि आपके खिलाफ केस हो सकता है, तो उस केस में आप एंटिसिपेटरी बेल फाइल कर सकते हैं। उसके लिए ज़रूरी नहीं है कि आपको पता हो कि आपके एफआईआर का नंबर क्या है, या एफआईआर किस सेक्शन में हुआ है, या फैक्ट क्या है केस के। अगर नहीं भी पता है तो आप कोर्ट के सामने जाके बोल सकते हैं कि हमें ऐसा ऐसा लगता है, अप्रीहेंशन है कि हम मेरे ऊपर कोई केस हो सकता है, तो उसके लिए आप बेल दे दें। और एंटिसिपेटरी बेल आप डिफरेंट स्टेज पे भी मांग मांग सकते हैं, जब तक और जब एंटिसिपेटरी बेल, उससे पहले जो भी मैंने बोला है, अगर किसी को कंफ्यूजन हो बिकॉज ऑफ द लैंग्वेज तो मुझे प्लीज़ बता दें, मैं उसको थोड़ा सा ब्रीफ कर दूंगा। फिर ये जो सारे टाइप्स के बेल थे, बेल कन्विक्शन सॉरी बेल लेवल ऑफेंस में बेल आप मैटर ऑफ राइट है, फंडामेंटल राइट है, ये आपका हक है, ऐसा आप करके बेल मांग सकते हैं कोर्ट से। लेकिन उसके लिए आपको कोर्ट से रिक्वेस्ट करनी जरूरी है बेल लेवल ऑफेंस में भी। अगर आप रिक्वेस्ट नहीं करेंगे तो ऐसा नहीं है कि बेल लेवल ऑफेंस है, मैंने कुछ कोर्ट में पिटिशन डाला नहीं, कोर्ट जो है खुद से आपको बेल पे दे देगी, नहीं। दूसरा मैंने बताया कि कैसे जो है नॉन बेलेबल ऑफेंस में आप बेल ले सकते हैं। नॉन बेलेबल ऑफेंस में बेल नहीं देना है, लेकिन ये डिस्क्रिशनरी, यानी वो खुद की मर्जी होती है, जज की एक मर्जी होती है, लीगल एक्यूमेन को देखते हुए, फैक्ट को देखते हुए, केस की इम्प्लीमेंटेशन ऑफ लॉ को देखते हुए, ऑफेंस की ग्रेविटी को देखते हुए कोर्ट डिसाइड कर सकती है, इरिस्पेक्टिव ऑफ एन नंबर ऑफ जजमेंट्स। मान लो सुप्रीम कोर्ट ने बोला है कि इन केसेस में बेल नहीं देना, या सुप्रीम कोर्ट ने बोला है कि मर्डर के केस में आप बेल नहीं देंगे, या उन केसेस में जिसमें लाइफ इम्प्रिजमेंट आप बेल नहीं देंगे, फिर भी कोर्ट बेल ग्रांट कर सकती है, क्योंकि वो एक कोर्ट की खुद की पावर होती है, डिस्क्रिशनरी पावर होती है, उसमें किसी का इंटरफेरेंस नहीं हो सकता। उसके बाद फिर मैंने बात किया कि मैंने आपको बता दिया एंटीसिपेटरी बेल के बारे में, ठीक है। फिर मैंने आपसे बात की डिफॉल्ट बेल। डिफॉल्ट बेल के बारे में मैं ये बता दूं, एक स्पेसिफिक इन्वेस्टिगेशन करने के लिए, या फिर आपको 24 आवर्स के दौरान जो है मजिस्ट्रेट के पास पहुंचना होता है। किसी ने कोई क्राइम किया, अरेस्ट हुआ, तो विद इन 24 आवर्स आप जो है जज के पास जाएंगे। अगर आप नहीं जाते तो वो मशीनरी फेल हो जाती है। ये उस बेसिस पे कि इसका कुछ इल इंटेंशन था इन्वेस्टिगेशन अथॉरिटी का, तो इसके लिए इन्होंने डिफॉल्ट किया है, तो मुझे बेल चाहिए। कुछ सिचुएशन में इस तरह से भी बेल हम ले सकते हैं डिफॉल्ट बेल में। वेर एज इन्वेस्टिगेटिंग अथॉरिटी के पास ये एक स्पेसिफिक डेज होता है, जैसे 90 डेज है, 60 डेज है, जैसा केस है नेचर का। उस हिसाब से अगर विद इन दैट पर्टिकुलर पीरियड अगर आप जो है इन्वेस्टिगेशन फुलफिल नहीं करते हैं, तो फिर जो एक्यूज्ड है उसको आप जो है वो डिफॉल्ट बेल की कैटेगरी में आ जाता है। अगेन यहाँ पे एडवोकेट का होना इसलिए ज़रूरी होता है कि अगर आपको पता नहीं है कि हम डिफॉल्ट बेल में लाई कर रहे हैं या नहीं कर रहे हैं, तो उसकी बेल पिटीशन लगाएगा कौन? मतलब आपको अपने हक के लिए बोलना पड़ेगा। ये एक बहुत बढ़िया प्रिंसिपल इस बेल को देते वक्त, बेल पिटीशन को पढ़ते वक्त मेरे को समझ में आया था, जो मैं आपको शेयर कर रहा हूँ। कि जब तक
Okay.
आप कुछ, हाँ प्लीज प्लीज रिकनेक्ट करें,
हाँ, 1 मिनट रह गया है, तो हम रिकनेक्ट करेंगे सेम
प्लीज प्लीज,
another
हाँ।
share to all of you and you have to rejoin it. Okay,
ओके ओके
30 participants are there, so please rejoin. I'm sharing new link through Google through this group and also to the speaker. Okay,
ओके
Okay, sir, I'll
Utkarsh?
just.
Yeah.
Sure.
Okay.
Wait, okay, sir, I'm doing it.